Good afternoon. I'm Dan DeRose with 19 News, coming to you from our digital desk. We need to talk about the latest movement in the stadium showdown. A judge in Columbus this morning went ahead and blocked temporarily a 14-day restraining order, the $600 million in unclaimed funds. Let's catch up to speed here. It was this summer that lawmakers passed and the governor signed a bill that would have taken $1.7 billion out of the unclaimed funds. What are unclaimed funds? Very simple. It's old bank accounts that have gone dormant. The bank doesn't just get to keep that money, it sends it to the state, and the state holds it until somebody comes to collect it. Now, there's several other sources. It could be class action lawsuit money that was never accepted, maybe insurance payouts that were never accepted. According to lawmakers, they were only going to take $1.7 billion from money that was 10 years or older, that had been sitting there for at least 10 years. People can still go in and claim their other funds. All total, there's somewhere of over $4 billion sitting in that fund. Not everybody agreed with that use of the money. In fact, a lawsuit was filed, and that's what got us to today. There was a lawsuit filed by former Ohio Attorney General Mark Dan claiming that this is an inappropriate use of the money, and for at least temporarily, the judge blocked that money from being sent to the Browns. The Browns were going to get $600 million of it. The rest of that money was going to help with other stadium or culture products. Think about museums. I think of Severance Hall. Maybe they want to do renovations. They would have been able to claim some of that money, or at least put in for it. So we are going to welcome in former Attorney General Mark Dan. Sir, thanks for joining us. How are you today?
I'm well. Thank you for having me.
I think when I spoke to you this morning, I think you said it was a good day.
Yeah. It's an early Christmas present for people who think government shouldn't take your money without compensating you, or without any due process of law. The judge, I think, saw clearly that we have a very good likelihood to succeed on this case, and appropriating other people's money to give a subsidy to the Cleveland Browns and other sports teams isn't a constitutional way to do it.
So let's expand on that just a little bit. The governor didn't want it done this way. The governor was hoping we would increase taxes on sports gambling, but the legislature saw it different, and this was passed by both the House and the Senate. The public is who votes those people into office. They voted for it, they passed it, and the governor signed it. I'm being devil's advocate. Why are you pushing so hard against what you could say is the majority?
Well, both the U.S. Constitution and Ohio's Constitution have very specific provisions that say if the government's going to take your money, first of all, they have to do it for a public purpose, and that money, and there's a Ohio Supreme Court decision right on point called Sogg versus Zers, that says that money belongs to the owners of the money. So if you had a safety deposit box that was liquidated by the bank, or you had a stock account, or your relative died and you were entitled to insurance proceeds and the insurance company couldn't find you, all that money belongs to the people to whom it was intended, not to the state of Ohio. Ohio was holding it kind of like a lost and found. What the legislature in the middle of the night during the budget process back in June decided to do was to take that money as of January 1st, 2026, and keep it, and then use it to give a subsidy to sports and cultural facilities, with a specific earmark of $600 million for the Cleveland Browns indoor stadium in Brook Park. And there's so many things that are offensive about this, but the fact is that it's the violation of the constitutional rights of the people that have money in that fund. And they're entitled to notice and the opportunity to have a hearing. For example, if they sell your stock in Apple, depending on when they sold it, the value of that stock may be different than the state thinks it is. You're entitled to a hearing on to determine that amount. If the state takes your money for anything, it has to be for a public purpose. I think there's a really good argument that it's not a public purpose to build an indoor stadium for a billionaire. And then third, if there is, even if the court were to decide, or it was a public purpose to build an indoor stadium for a billionaire, then you have to compensate the people whose property you're taking for that. And you have to do it under Ohio's constitution before you take it. So, and this happens a lot in the context of like roads. If they want to put a new road through your neighborhood, the state can do it, but they have to compensate you for it. They have to give you notice and the opportunity to be heard on what your property's worth. And then a jury can decide how much that property's worth. That's what every person in the Unclaimed Funds fund should be entitled to.
And just going to play devil's advocate again, they're not
Yeah.
taking all of the $4 billion. They're taking 1.7, and they're taking some of the oldest money that's been sitting there, 10, 20 years that it's been sitting there. Explain that side of it, that, they're not saying that you can't claim your money anymore. There's still going to be a sizable amount of money sitting there that people can claim money.
Yeah. But what the judge said, I thought was very apt. And he said that they're robbing Peter to pay Paul. They're saying that if you do make a claim on those funds after we've transferred them to the state, then those funds can come from somebody else's money that's been put in the unclaimed funds account. And it's a slippery slope when government starts to take your property without giving you due process of law or compensating you for what they've taken.
So what would make you happy that, let's say, and I'm just going to make up John Q. Public. There is a guy, John Smith, that has had money sitting in that account for 35 years. It's $20. That should never be touched. John Q. Public is dead. They have no family that they can track down. That money should just sit there forever?
Well, they should have, from the time they took it, they should have notified individually Q Public, and that's not what's happened here. Those funds, so they put the burden of notifying people whose money goes into the unclaimed funds account on the bank or the institution that's submitting the money. The government doesn't control that. The government doesn't. You don't get a letter, official letter from the government saying that your money's been seized and is going to be held by the state of Ohio. So there's no and for under $50, you don't even get that. You get nothing at all. So John Q. Public would have had no idea that he had, or certainly legally no idea, that he had money in that fund, and no opportunity to raise claims about the value of it and whether he owned it or not.
But I'm sure it'll be argued by the other side. There's been a website for 10, 15 years that anyone in the public can go look up their name. So that's going to be the argument for the other side. This isn't coming out of the blue. This wasn't something.
But that notice, and that notice has probably never been constitutional. The state's required to provide individualized notice, and I think that's a pretty clear legal standard. And none of it has taken place. Now the state wants to take it a second time. So they took it once and held it in trust. So it's not a taking because the state wasn't using that money for whatever purposes the General Assembly decided to use that money. That money was off limits. Suddenly, in the middle of the night in the budget process, they decided, okay, we're going to tap into that money. Rather than have the courage, if necessary, to raise taxes to reward our campaign contributor Jimmy Haslam and to send money to the Cleveland Browns Stadium, we're going to take your money and do it, but we're not going to give you any individualized notice of that. For example, one of our clients' name is John Reed. I encourage you, Dan, to take a look at the Unclaimed Funds website and see how many John Reeds there are. For him to identify what funds he has in there to even raise these issues is a challenge for somebody in that situation. So the state is just not doing its job. It is not meeting the requirements of the state constitution, and that's what the judge decided today.
So this is now being pushed to January 8th. I mean, something has to move here. You've got a 14-day window. This payment was supposed to be made on January 1st. What happens January 8th?
January 8th, there's another hearing for what's called a preliminary injunction, and we have to once again prove uh, that the one that we're going to be successful on the case, and I think that we'll be able to do that, and two that the state wouldn't be harmed by just maintaining the status quo, and I don't think the state would be harmed in any way. Yeah. And then the court can decide by taking in an appropriate process for a lawsuit to take place over the course of the next several months, whether or not this process is constitutional or not. If we're right, then a permanent injunction would issue and it would never happen. If we're wrong, then the state can go ahead and what they call sheet that money, which just is a nice word for stealing, and use it for whatever purposes that they want to use it. I feel very confident in our case, and I think that we'll. At the end of the day, is there a constitutional way for the state to do it? Yes, but it takes the courage to provide individualized. What they wanted this all to happen was, this bill was passed in the middle of the night. They wanted to go under everybody's radar. That nobody will even know that their money was taken. It was they thought they had committed the perfect crime here, but they got caught, and they have to follow the rules, and the rules that we set for how the General Assembly is to behave is in the Ohio Constitution, and how the administration in carrying out the wishes of the General Assembly is to behave. And that is that if you're going to take somebody's property, and this goes back to the Revolutionary War. Remember the history class where the British soldiers were quartering in the homes of the American revolutionaries. When we won that war, we decided we didn't want the government to be able to do that. There's no kings here anymore, and so the government has to give you notice, give you the opportunity to be heard, and if they're going to take your property for a public purpose, they have to do it. They have to do it by compensating you. And if they're going to take your property to give to a private individual to build a monument to himself in an indoor stadium, then they can't do it at all.
Former Attorney General Mark Dan, he is on the litigation side of this case, literally about the last roadblock that stands in front of Dee and Jimmy Haslam from getting the Brook Park project built. This is about the last-ditch effort. Could they come up with their own $600 million if this falls through? Well, I've asked that question. We have not gotten a comment back from the Browns today. We'll wait and see. Former Attorney General, Mr. Dan, thank you much for the time. We truly appreciate it.
Thank you for the opportunity.
All right, take care. We will follow this. Obviously, January 8th will be the next court proceeding down in Columbus, and we'll keep our eye on that as well. Until then, I'm Dan DeRosa with 19 News. Make sure you tune in to 3.5 hours of news and First Alert weather on Channel 19 coming up at 3 o'clock. Have a great holiday season.